Good afternoon. Our next case is in re Godfrey, and we will hear from the appellant.
Mr. Chief Justices of the Supreme Court of North Carolina, may it please the court. My name is Joseph Frost, and I represent the respondent appellant, Virginia Lee Godfrey. This time I'll reserve 5 minutes for rebuttal. This appeal from a divided panel of the Court of Appeals deals with the effect of a dissolution of a 37-year marriage, an uncontested divorce, and forged loan documents have on the otherwise bland requirements of a non-judicial foreclosure proceeding under Chapter 45 of the North Carolina General Statutes. At issue here, in this case, is whether the Court of Appeals erred in reversing the trial court's order denying foreclosure and then subsequently holding that the petitioner had satisfied the 6 criteria required to institute a non-judicial foreclosure. Specifically, whether Ms. Godfrey, or the respondent, ratified loan documents that were void based on their failure to comply with the statute of frauds. The Court of Appeals erred in reversing the trial court's order denying foreclosure for the following reasons. First, there was overwhelming evidence presented to the trial court, which it considered, weighed, that properly supported its findings as well as its conclusions, that the petitioner, in this case, Paper Profits, failed to prove and establish the existence of a valid debt and the right to foreclose under Chapter 45, 2 of the 6 requirements that are required for a non-judicial foreclosure. Second, contrary to the Court of Appeals finding, Ms. Godfrey did not, through her actions, conduct, or omissions, ratify this subject loan transaction or otherwise take any action that would have been deemed to ratify the otherwise forged and void loan documents that are at issue in this case.
I guess that, excuse me, that the question I have is in the equitable distribution orders that the trial court entered in the family court proceeding, the court at some points provides more information than we sometimes would otherwise see from courts in doing an unequal distribution. One of the things the court said very expressly is that, and as I understand it, your client, this is essentially all from representations of your client because Deese, I think, is not participating, right? So the court says these are jointly held debts and then goes on to explain the importance of the unequal distribution, giving the home to your client because she is obligated to pay that debt, and having the home in her name be important in order to refinance it or take some other action in order to make sure she can pay that liability. So how is that not going to either be ratification or judicial estoppel? Because the court, we can see the trial court in that proceeding certainly would not have done what it did if your client had said, I don't have to pay this debt. I never signed the paperwork. It's void. Any of the arguments you just made to us right now. So what's your response to that?
Certainly, Your Honor. I don't think that I think underlaying in all of the trial court's findings in that otherwise uncontested divorce is the fact that prior to that divorce, as of, I believe it was December of 2016, Mr. Deese completely absconded. Nobody knows where he is. To date, no one knows where he is. That is, I believe, Your Honor, is the contributing factor in why there were such detailed findings about why she needed the property solely in her name. It's pretty, I think the statements made and the verified pleadings in that domestic action illustrate primarily that she had no ability to refinance or do anything with the property because it was held as tenants by the entirety. As a result, even though Mr. Deese has absconded, he certainly is not going to sign anything in absentia or on the run from the Securities Exchange Commission. So that's, I think, Your Honor, why there was such detailed findings about the need and the urgent need to do that. I think that there is a distinction that should be drawn as well, to answer your point, between jointly held debt obligations and marital debt. There is absolutely no finding in any of that domestic action that this was a marital debt. I think the main concern and the reason that it was so urgent to do it roughly 60 days after the actual domestic action was filed, was to get the property solely in her name because things had already been discovered as being irregular. The fact that there's substantial tax debt, as Your Honor reviewed in the domestic action, there are other debts that my client was not aware of. And primarily, Your Honor, it's not ratification because there is absolutely no evidence, and actually there's evidence to the contrary that when that domestic action was filed, that she had any idea that these documents were forged. This court has said on numerous occasions that in order for it to be ratification, one has to discover the unauthorized act. And it's plainly clear before the trial court and there's nothing in that domestic action that indicates that she knew of the underlying unauthorized act being the forgery of her signature on those loan documents.
I guess my point, though, was she would have known that she never took out that. Your client would have known that she didn't take out the loan. And it certainly reads, when I read that equidistribution order, as if the court was assured there that this was a loan that she believed she had to pay back personally, and would not have done what the court did there without that. If instead your client had said, I don't know what's going on here, but maybe Deese took out these, but I certainly didn't, and so we're going to have to sort something out because at least part of the home is mine. I can't be responsible, and none of that happened. So to me, that seems like a pretty strong judicial estoppel argument to come back later and ask another court to now say that I don't have to comply with this debt.
Well, and your Honor's point's taken. I don't think there was any admission or any position taken in that domestic action that's completely inconsistent with the action that was taken in this underlying special proceeding, i.e. the invalidity of the debt. I don't think the validity of the debt was not at issue at all in that domestic action. And those findings that were made by the trial court was mainly findings that were necessary to justify as you said, an unequal distribution and the immediate transfer of the property into her name prior to entry of any equitable distribution judgment in that action. Which brings me to my third point as to why the trial court's order denying foreclosure was correctly found, and the Court of Appeals erred in reversing that. These subject loan documents, I believe, unquestionably are void and that they do not comply with the statute of frauds. All the overwhelming evidence in this case suggests that Ms. Godfrey did not sign, was not aware of until the special proceeding was filed that these loan documents were signed. And one of those documents being a deed of trust, which any conveyance of real property under Chapter 22-2 of the North Carolina General Statutes has to be in writing or it's otherwise void. There's no question whether or not it's void. The third argument, Your Honors, is that based on this failure to comply with the statute of frauds and the fact that these loan documents are void, this court on at least 3 prior occasions has held that a void contract, a void instrument, cannot be enforced through the doctrine of ratification. In other words, the court is not going to utilize ratification to enforce an otherwise void agreement or otherwise void contract. Or for that matter, it will not utilize estoppel to otherwise enforce a void instrument or a void contract. That's a particular area, although argued at the Court of Appeals below, they completely disregarded and or did not address that concept that these 2 doctrines, both equitable in nature, are completely inapplicable in this situation. Briefly, just by way of background,
Can I just ask you doctrinally, if there's a contract that's subject to the statute of frauds and on one of the contracting parties there's actually 2 contracting parties and one signs, the other doesn't, could that second party though still be bound because of a doctrine like ratification or estoppel? And isn't that more like the scenario here than what you're describing?
But for the fact that this is tenancy by the entirety, and but for the fact that under Chapter 41-58, both husband and wife, in order to convey an interest in real property, have to both sign. And the allegation being that Ms. Godfrey did not in fact sign and that was not her signature on those documents, I think would support the invocation of that doctrine of not allowing ratification to otherwise allow Mr. Dees to benefit from the forgery of Ms. Godfrey's signature on those documents. And I hope that answered your question, but certainly I think, but for the fact that we're dealing with a husband and wife at the time, they're not husband and wife anymore, but I think certainly separately Mr. Dees would be liable under the operative loan documents. Certainly the operative question here is whether or not the deed of trust is sufficient to impart a lien on jointly held property as tenancy by the entirety. In this case, because Ms. Godfrey did not sign that, trial court, our position is the trial court properly found that there was no right to foreclose because there was not a valid lien based on the overwhelming evidence that was submitted to the trial court that Ms. Godfrey did not in fact sign. And it's not just as probably my friend will characterize as self-serving statements. There was also sworn testimony from a forensic document examiner who has over 50 years experience, who worked with J. Edgar Hoover at the FBI, that examined at least 12 separate signatures of Ms. Godfrey, who concluded and gave an opinion, an expert opinion, that was not in fact her signature on either the underlying credit agreement or the deed of trust.
So we're here on an appeal of right based on the dissent, right?
That is correct, Your Honor.
It seems to me that many of the arguments you're making go beyond the scope of that dissent, which really is about whether Ms. Godfrey's behavior amounted to ratification.
Certainly, Your Honor, and I was not intending to go outside the scope of that. Certainly, I agree with Your Honor. The scope of this court's review is whether or not the Court of Appeals' conclusion that Ms. Godfrey ratified through her actions the otherwise void subject loan documents, and whether or not that established the two requirements under Chapter 45, the validity of the debt or the existence of a valid debt, and the right to foreclose. So moving then to the ratification issue that the Court of Appeals drew. Ratification under North Carolina law is clearly the affirmative action taken either expressly or impliedly through one's actions or omissions of a prior unauthorized act that is given such that that prior unauthorized act is given credence such that it is authorized at that point. Two requirements for ratification, one being the intent to ratify, two, the full knowledge of the material facts. The latter of those requirements is issued in this case. There is absolutely no evidence in the record that would suggest that Ms. Godfrey knew of these forged loan documents prior to the commencement of the special proceeding. There's no evidence that she took any action, much less the actions that the Court of Appeals delineated in its opinion, to expressly or impliedly authorize or condone that unauthorized act. And as I mentioned before, one of the threshold requirements for the application of ratification is the discovery of the underlying act. I think the undisputed evidence by Ms. Godfrey, which was not rebutted in any form or fashion by the petitioner before the trial court, was that she had absolutely no knowledge of this unauthorized act until such time as the petitioner moved to enforce or to commence a foreclosure proceeding against her relating to this property. In addition,
in the final equitable distribution order, where the court says, I dealt with this in this interim order, and based on that, here's how I'm distributing, I think, it's a class 5 value, and distribute this marital assets and liabilities, and then it discusses that home equity line of credit, right? So I guess wouldn't we be, if we said now that that can't be the case. At most, this was D's a separate property where he may have some liability for that loan, but your client does not. I mean, wouldn't that be allowing your client to collaterally challenge the court's determination there? I mean, isn't that somehow binding now that the court made that determination? There's no appeal from that proceeding?
I don't think it would be binding, Your Honor. I don't think in the final distribution, equitable distribution judgment that was entered, I believe, in 2020, it actually didn't classify specifically like it did with much of the other debts and property as whether it was marital or separate property. I thought that intriguing when I reviewed that, but certainly I believe the final equitable distribution order does not in fact label this debt or this property as marital or separate, either or. With that being said, I don't think my client is collaterally attacking it because the issue of the validity of the underlying debt was not litigated in that underlying action. And I believe it's evident from my introduction, uncontested divorce, Mr. Dees is absconded, he's not appearing. So certainly at best this is a divorce by default. So there is no collateral estoppel effect to that underlying judgment because and not to mention the fact, Your Honor, that the bank or the holder of that note was not a party to that underlying divorce proceeding. And if the roles were reversed and for example, that hypothetically speaking, if that equitable distribution judgment would have said, Mr. Dees is solely responsible for this loan and Ms. Godfrey has no responsibility for an ever and ever, that's not going to preclude the bank from trying to collect for Ms. Godfrey. They're going to assert that that does not stop them because, and the argument probably would be that, hey, this is an equitable distribution action. We're not a party to this. The court doesn't even have jurisdiction to address the validity of the underlying debts. It's mainly there to classify marital versus separate and to equitably distribute the assets as they see fit. But circling back to the Court of Appeals, the majority found three, instances where they contend that conclusively established that Ms. Godfrey ratified this underlying transaction. We've spoken about the first one relating to the statements made in the verified pleadings in the underlying domestic action. The second being the subordination of this loan under subsequent, at least two subsequent subordination agreements. Again, as the dissent pointed out and Judge Hampson pointed out, that's a red herring because Ms. Godfrey was not a party to those subordination agreements, had no idea they were in existence, and ultimately did not benefit from those subordination agreements. The only party that benefited from them subordination agreements were the lenders themselves, the only parties who actually signed those agreements. So I'm not sure how a action taken by two third parties of which my client was not aware at the time or subsequent to that, and she did not receive any measurable benefit from, would constitute an act of ratification that would be sufficient to support recognizing the validity of the underlying transaction. The third was the evidence in the record that the proceeds of this transaction, $150,000, were used to satisfy prior obligations for which she was liable. And that's just incorrect. The record is not, there is absolutely no evidence in the record that the proceeds of this loan were used to satisfy prior obligations. In fact, all of the prior obligations, excuse me, that could have been satisfied were in fact satisfied 2 years earlier than this subject loan was taken out. The other outstanding obligation that they pointed to that could be used to satisfy that was actually satisfied 7 years after the subject transaction took place. So it's just a physical impossibility for the proceeds of this loan to be used to satisfy existing debt. And ultimately, as I mentioned before, neither of the subordination agreements she was a party to either one of those. Also, those subordination agreements, which are in the record, don't make any determination as to the validity or enforceability of either of the loan documents. The loan documents themselves, in the event a party thereto does not sign them, for example, paragraph 20 of the underlying note says that only parties who execute this document are actually liable thereunder. So the absence of her signing it would render the underlying debt invalid as to her. As I mentioned before, she has not taken any action or received any measurable benefit whatsoever from this transaction. In fact, she had absolutely no idea the transaction took place until we had this special proceeding, and she looked at her signature and saw that that was not her signature. And all of that is in the record. All that was reviewed by the trial court. All of that, and I will mention that in addition to the evidence that I'm recounting about the subordination agreements, the domestic action, and the like, all of that was reviewed by the trial court. All that was presented to the trial court. That was appropriately weighed. It was included within its findings, and it supported its findings, which in turn supported its conclusion. Because, I mean, in fact, there was absolutely no evidence that she took any action relating to this transaction. It did not condone the forgery or otherwise. The only evidence in the record is that as soon as that forgery was discovered, when the underlying special proceeding was filed, we commenced with a contested special proceeding where at the forefront was her allegation that, hey, I did not sign these documents and these things are not enforceable, and you otherwise have not complied with the statutory requirements under Chapter 45.
Can I ask you about whether the record shows that she made payments on this loan from December 2016 until October 2018?
I apologize, Your Honor. Could you please repeat that question?
That she, and I think this is on record, page 300, but that she made payments, and so I'm actually asking for clarifications, maybe this is wrong, but that she made payments on this loan from the parties' separation until the interim distribution judgment.
Yes, that's the finding that was made in the interim distribution judgment, that there was payments made. However, even if payments were made, there's evidence in the record that at the time the payments were made, she had absolutely no idea and had not discovered the unauthorized act, the forgery of her name on those loan documents. The trial court considered that, and in accordance with this court's precept in connection with ratification, there cannot be a ratification until you are in fact aware of the underlying unauthorized act. And the evidence suggests that in 2018, she was not aware of the unauthorized act. And the evidence suggests as soon as she became aware of that, there was no action taken with respect to this transaction that would have otherwise constituted ratification. Third, as I mentioned previously, the Court of Appeals, in reversing the trial court's order and denying foreclosure, the subject loan documents are void and they cannot be enforced through doctrines of ratification or estoppel. A void contract, as I mentioned before, cannot be a basis for ratification or estoppel. This court's decisions in Bolin, Jenkins, and Spence all confirm that, all dealing with, specifically in Bolin, dealing with, and the court refused to apply ratification and estoppel to a separation agreement that did not comply with the requirements of Chapter 52 of the North Carolina General Statutes. As a result, this court held that separation agreement is void because it did not comply with those statutory requirements. It also, even though the parties attempted through their actions to abide by that agreement, this court refused to allow ratification or estoppel to enforce that agreement. The same with Jenkins. In that case, the contract, which was statutorily required to be in writing, was void, and this court found It was absolutely or incapable of ratification. Because the contract was void, it could not be enforced through any doctrine of ratification. Similarly, in Spence, an employment contract with an employee for 12 months. It's somewhat of an older case, 1894 case, but an employment contract by a corporation, apparently back in the 1800s, for 12 months had to be in writing. That case, it did not. It was not in writing, and it was for longer than 12 months. This court refused to enforce that contract, even though the parties were operating and had taken actions in furtherance of that contract under the doctrine of ratification, holding that this court would not enforce a void contract based on the doctrine of ratification, even if the parties demonstrated a willingness and ability to comply or to perform. With that being said, and in conclusion, I think it's simply put here, I mean, the trial court made findings of fact and based on those findings, made conclusions of law. Those findings of fact were supported by competent evidence that we've discussed today, and the trial court mulled over in the course of the hearing, de novo hearing that was held. And it concluded the absence of the existence of a valid debt and the right to foreclose. Two elements that Paper Profits was required to prove and bore the burden of proving in a Chapter 45 non-judicial foreclosure. Because they failed to carry that burden, the trial court properly refused to permit the foreclosure. And based on the foregoing, this court should reverse the Court of Appeals and adopt the reasoning set forth in the dissenting opinion and confirm and reinstate the denial order entered by the trial court denying foreclosure. With that, I'll reserve the balance of my time.
Thank you, counsel. We'll hear from the appellee.
Chief Justice Newby and Associate Justice of the North Carolina Supreme Court. May it please the court, my name is Alan Pressel, and I represent the petitioner, appellee, Paper Profits, LLC, which is the note holder in this Chapter 45 non-judicial foreclosure proceeding, which was commenced back on July 26, 2021. As you've heard from Mr. Frost, the only items at issue here are the validity of the note and deed of trust. Ms. Godfrey contends that it is not her signature on these instruments, and therefore they're not enforceable, and the deed of trust may not be foreclosed. Even assuming that she did not sign the documents, the Court of Appeals correctly held that they are valid and enforceable because she ratified them.
So it seems to me this is, and I'm going to sort of paraphrase your friend's argument a little bit, but the argument seems to be, yes, I paid the loan payments leading up to the interim distribution order. I filed a verified complaint that said this was jointly held debt, and yes, the court relied on those representations to find that it was jointly held, but that I could refinance it in my sole name in order to keep the house, which was also going into my sole name. But all of that was done in the context of the family court proceeding, where the focus is making sure that, because Dee's the husband, just out of the picture, that I can take care of all these assets, because if I don't pay, obviously there will be a foreclosure. But never to be an admission that I actually hold the debt, and it's sort of like implied I'm reserving the right to go to the bank and challenge and say, no, I never even signed this, I'm not paying it. And so none of that proceeding should have anything to do with the arguments in opposing the foreclosure. That seems to me to be the argument. So what's the response to that?
The response is that that is not a position that makes any sense. She filed a verified complaint admitting that this was a joint debt. Actually, there were two debts at the time, two loans, which was secured by the property. She admitted it in her pleadings to the court. And she can't now, later on, say, well, that was just for some limited purpose and you can't use it against me in a subsequent proceeding. And Mr. Frost argues that since the bank was not a party to that transaction, it's not a valid use against them. He's ignoring the doctrine of non-mutual defensive use of collateral estoppel, and therefore those findings in the court, her admissions, as Your Honor noted, she was the only party in that domestic action. All of the evidence, all the admissions, all of the facts and evidence came from her. So, and the court, the judgments entered pretty much mirror her complaint and other filings. I would assume that her attorney drafted those documents for execution by the court as the judgments. The court made the same findings that she asked the court to find. She had a loan. She knew about the loan. As Justice Earls noted, for 2 years, from 2016 to 2018, she made $12,000 in payments on that loan. And that was after her husband had left her. The loan was from 2003. In 2016, the loan was paid by one or both of the borrowers, and he was out of the picture in 2016. And from the next 2 years, she personally made those payments on the loan. So she knew about the loan. She had every opportunity to take some kind of action and say, that's not my loan. And she chose not to. She knew the loan was coming to be matured, and that it's an equity line of credit, and the entire balance would be due in a month or two from her filing with the court. And in order for her to do something with the property and save the property from foreclosure or other action, since her husband, as Mr. Frost noted, was not in the picture, he wouldn't cooperate with signing any documents and deed the property over to her or do anything else, she needed it solely in her name. And so, in order to get the property and the loan solely in her name, she represented to the court, these are valid joint debts, and we have to go ahead and take some curative action so that I can save my property. And so she got the judgments, giving her sole title to the property and sole responsibility under the loan, but then took no other action. It wasn't until the foreclosure was commenced 3 years later, she took absolutely no action on the loan to try to refinance it or do anything else to pay off this equity line of credit. And even when the foreclosure was commenced in 2021, it's in the record, her attorney filed a motion to continue the initial foreclosure hearing. And in that motion, all he did was request more time to try to resolve this debt and work something out. There was no allegation at that time, when the foreclosure was commenced, of any fraud or non-signature by Ms. Godfrey. And so she did not promptly and definitely not immediately try to repudiate the loan. And that's another factor in the ratification process, whether or not a party repudiates the loan. And she did not. It's from 2016 that she had full knowledge of the loan. We would argue that she had knowledge from 2003, but the evidence, the record is clear that as of 2016, she had full knowledge of the loan. I don't think Mr. Frost's argument that she claims she didn't know it was forged at that time is determinative. She knew about the loan, and her actions are inconsistent with any conclusion that she thought this loan was not hers and she did not ratify it. She filed that lawsuit notifying the domestic court this is a valid loan, paid on it for 2 years before that, and took no further action to repudiate it at that time. If I just may go back through some of the, a little more detail about the property loan itself. As the record shows, Ms. Godfrey and Mr. Dees acquired the property known as 2500 Arthur Means Road in Hillsborough in 1998. It's a 63-acre plot of land. It was funded with the initial loan. As the record shows, there were 7 loans that were taken out over the next 15 years. The initial purchase was for $740,000 in June 30th of 1998. At that same time, there was a $100,000 equity line of credit. Both of those were with Triangle Bank, which is a predecessor to RBC Centura. 2 years later, in 2000, they got a new equity line of credit for $300,000 with Centura Bank. 3 years later, that was reduced from $300,000 through a modification to $100,000 line of credit. In 2002, they obtained a $983,000 loan from RBC Centura. And then the next year later was a subject loan in October of 2003 for $150,000 equity line of credit. And then in 2007, refinanced the primary loan for approximately $869,000 with RBC Insurer again. And then finally, it was refinanced again in 2013 for about $783,000 with Carolina Farm Credit. Mr. Frost noted those last two loans were required to and were subordinated to the subject equity line of credit. He's correct that the borrowers, Mr. Dees and Ms. Godfrey, were not signers on the subordination agreement. The borrowers are not. That's an agreement between the lenders to subordinate their loan. But the only way you can get a primary loan after an equity line of credit is to have it subordinated. Otherwise, a lender is not going to want to be in second position with an $800,000 loan junior to a $150,000 equity line of credit. And Ms. Godfrey could have proven at the time that she had no knowledge of the subject equity line of credit by submitting into evidence in the contested foreclosure her loan application regarding the subsequent refinances in 2007 or 2013, which, if she had no knowledge of it, would not have shown this equity line of credit as a liability as well as security on the property. But she did not present any such evidence which would have buttressed her argument that she had no knowledge of the subject loan. The only evidence that was presented to support her argument of her position that she did not sign this loan, as Mr. Frost correctly surmised, I would refer to as a self-serving affidavit, saying that that's not her signature. And in support of that, she obtained an affidavit from an expert witness corroborating her assertion that it's not her signature. We rebutted those affidavits with our own affidavit from the notary, who notarized the signature of Ms. Godfrey and Mr. Dees at the closing. She acknowledges that it's been 18 years. She does not recall the specific transaction, but her standard policy and procedure, when she doesn't know the signing parties, is to look at their state-issued identification and confirm that these are the parties signing this document. And she said she always does that and would have done it in this transaction. The Court of Appeals assumed that for purposes of their opinion, the loan documents were not signed by Ms. Godfrey. We don't believe the evidence was sufficient to support that finding or assumption. We believe that Ms. Godfrey would need to present more evidence in a self-serving affidavit. She chose not to appear or testify at the foreclosure proceeding and just submit her affidavit. But even assuming the loan documents were not signed by Ms. Godfrey, the Court of Appeals correctly determined that ratification applies here, and the facts support that she conclusively ratified the subject loan. As Justice Dees has already talked about, we have the domestic action in which she took actions which can only show that they are consistent with a finding that she approved and authorized retroactively, whether expressly or impliedly, the loan transaction. Whether or not there may have been fraud at the time, she knew about that loan, at least in 2016, and continued to make those payments and treat it as a valid debt and took no further action. We've already discussed the domestic action, so I'll skip ahead to my next point about ratification. Again, I've stated that she did not allege in the district court that it's not a valid or unenforceable debt at that time, and she did not immediately try to repudiate that in the foreclosure proceeding. Mr. Frost has relied upon the Espinosa case in support of his position that the loan could not have been and was not ratified. Espinosa's facts are distinguishable and different from this transaction. In Espinosa, the alleged borrowers did not sign the loan documents. There was no evidence they signed it. There was a third party that obtained that loan, obtained the loan proceeds, and the Espinosas had no knowledge about it. They had no communications with the bank in that transaction. And when they got notices from the bank and there was a foreclosure proceeding, they immediately repudiated it and said, that's not our loan. And the court discussed the application of ratification, saying positively that ratification could be applied to the non-judicial foreclosure proceeding, but determined that it would not be here because the evidence was indisputable that they had no knowledge and had not ratified that loan. Here, that's not the case. She knew about the loan. Mr. Frost has admitted that the loan is at least valid and enforceable against Mr. Dees, and there's been no allegation Mr. Dees did not obtain those proceeds from that loan, even if Ms. Godfrey claims she did not. There's no evidence that she did not receive monthly statements from the bank on this loan. Obviously, it was paid for 15 years, including the last 2 years, by her personally. So she can't claim to have no knowledge of this loan, and her actions certainly represent ratification because she knew about it, she communicated with the bank, and had absolute knowledge of it, and cannot now, it's distinguishable from Espinosa because of her actions within the underlying domestic action as well as everything else, and not immediately trying to repudiate it. The Court of Appeals also referenced the Davis case in support of their conclusion that ratification was conclusively established. In that case, ratification again was applied in a non-judicial foreclosure proceeding. In that case, the court found ratification did apply. In that case, there were 3 individuals purchasing a home, a husband and wife, and I believe it was the mother of the wife was a third party. And the husband's signature was done by the wife through a power of attorney. The allegation was that the power of attorney was forged, and therefore the husband did not sign those loan documents and could not be enforceable against any of them. The court said, you've known about this loan. At least two of the 3 parties participated and signed the documents. You received the proceeds, and you've made payments, at least sporadically, for 2 years. Sounds like similar fact pattern to ours, and said that they were acting in a manner consistent with recognizing the deed as legitimate. Respondents cannot now rely on the fraudulent actions of one of their own to their advantage. Therefore, the trial court was correct in finding the deed of trust as a valid and enforceable lien against the subject property. So there's precedent for the Court of Appeals opinion in this case in finding that ratification is applicable in these transactions and can conclusively establish that the loan is valid against a party even if they allegedly did not sign that document. Mr. Frost did not specifically mention the cases he otherwise referenced in his brief, but they are also distinguishable. The Rivera case he referenced. In that case, it's distinguishable because there was an argument about forgery on appeal and whether or not it was ratified, but they failed to, the trial court failed to consider the issue of forgery in the underlying court proceeding. And that was an error of law to not even consider forgery as a defense of the foreclosure. And therefore, they couldn't find ratification because there was no finding by the trial court, so it had to be remanded back for the court to consider that argument. It was never even considered. So it's distinguishable here because ratification was argued, and all of these defenses and arguments in favor of validity of the note were argued at the trial court in this case. The Hudson case is also distinguishable. In that case, the issue was whether or not the deed of trust had been altered prior to recording at the Register of Deeds, because the parties alleged that there was no legal description attached to the deed of trust when they executed it, and there was a legal description attached which they said the property described was never supposed to be involved in this transaction. That's not even close to the fact pattern here. There's no issue regarding the loan, the property at issue in this case. But again, the court said ratification is applicable in that proceeding. It was just not applicable to those facts and could not be sustained as a finding that ratification had occurred. The Foxden case is also not analogous to this case. On appeal, ratification was raised, but ratification was not raised to the trial court and therefore was not preserved for appeal. That's not the case here. Ratification was argued extensively at the trial court level. And so there's ample precedent for the argument that ratification and similar legal doctrines do apply in non-judicial foreclosure proceedings. As Justice Steets raised the doctrines of collateral estoppel and judicial estoppel, I won't go into them too extensively as already discussed, but the events in the domestic action, in addition to supporting a ratification finding, establish collateral estoppel and judicial estoppel. You can't go to one court, make an argument in support of your position, actually succeed on that argument, and then later on take a completely different position. Normally, they try to take a position that they lost and did not prevail at the prior proceeding. She actually prevailed and now doesn't want the benefit of her arguments at the domestic court action to be utilized against her in this proceeding. We also argued that we shouldn't even get to these arguments about whether or not she signed these. She shouldn't be allowed to argue she did not sign these documents because the statute of limitations has expired for any argument that she committed, that there was fraud or forgery regarding these loan documents. She obviously knew about the loan in 2016. You know, she alleges that she didn't know there was forgery or fraud at that time, but she knew or should have known there was at that time. She paid it for 2 years. In 2018, she went to court to get some relief regarding the fact that her husband was no longer in the picture. And it wasn't until 2021 in this foreclosure proceeding that she ultimately raised the issue. So for at least 5 years, she knew or should have known about this potential defense and didn't raise it. And now, this many years later, she can't argue that. NCGS 1-52 subsection 9 sets forth a 3-year statute of limitations for fraud. I've been trying to understand Mr. Frost's argument regarding the loan documents being void and therefore nothing can be done by Ms. Godfrey to resurrect these documents because they're void. The only conclusion that leads to is that he wants to abolish the doctrine of ratification or other doctrines. A loan document, just like most contracts, are not void as a matter of law because a party did not sign it. That's what the doctrine of ratification says. He's saying that it's void because of the statute of frauds and it must be in writing. The record has copies of the written documents. They're in writing. The argument they propose is that it's not signed. And the fact that it's not signed, you then look to other avenues to see whether or not they're still valid, and ratification, collateral estoppel, judicial estoppel are ways that those types of documents can be valid and enforceable, and they're not void as a matter of law. The case law he's relied upon talk about separation agreements between husbands and wives. The General Assembly has determined that those types of agreements have special requirements, and they must be notarized or otherwise have certain statutory requirements for them to be enforceable. And even if the parties want them to be enforceable, they can't if they don't meet those statutory requirements. There are no such statutory requirements regarding loan documents in these types of contracts. If the court has no questions, I'd like to move on to one of my final arguments, and that's the scope of the judgment or the order that the trial court entered in this proceeding. If this court does not affirm the Court of Appeals and find that ratification or otherwise the loan documents are valid and enforceable, we believe that the trial court's judgment or order goes beyond the scope of Chapter 45 proceeding and arguably it would operate as res judicata to a separate proceeding for judicial foreclosure or otherwise. The In Relux case, which was authored by Chief Justice Newby, holds that those types of proceedings, when the clerk or an appeal, the Superior Court does not find all the 6 elements to foreclose, does not operate as res judicata. So if it is ratification or otherwise the loan documents are not valid, on remand, that order needs to be altered so that it complies with the applicable law as set forth in the Lux case. And I want to go back to the argument I mentioned earlier about the self-serving affidavit. I'd be remiss if I didn't address the potential slippery slope of Ms. Godfrey's position in this matter, if it does become North Carolina law. It would allow any party, any borrower, to use, whether intentionally or otherwise, a unique signature on loan documents, and then continue to pay on these loan documents for years, fall into default, and then many years later, when foreclosure arises, they allege, I didn't sign those documents, that's not my signature. Look, it's different than everything else I've done in the past. I'm not accusing Ms. Godfrey of intentionally, doing something in this situation, but it leads to the slippery slope argument that any borrower could, when they're taking out a big loan, just make up a different type of signature, and it's not going to be difficult to find a handwriting expert to corroborate that that does not match your prior signatures. So it leads to the slippery slope argument that a self-serving affidavit such as this is sufficient competent evidence to overcome the validity of a note and deed of trust in a non-judicial foreclosure proceeding. It could lead to more difficult or possibly the inability of lenders to use Chapter 45 proceedings. It would lead to judicial foreclosures, which have required discovery, potentially jury trials. Lenders have to spend more time, money, and effort to foreclose, resulting in increased costs to future borrowers and clogging up our court system. Again, I realize that may be an exaggeration of what could happen, but again, a mere self-serving affidavit should not be sufficient in this case, especially when all the evidence contradicts her assertion that she did not ratify this loan. She was aware of it. In summary, her affirmative actions in paying this loan through 2008, including personally herself, from 2016 to 2018, $12,000. Her admissions and her requests and obtaining the judgment she requested in the district court proceeding for her equitable distribution and divorce. She was allowed and able to obtain 2 subsequent loans in the $700,000 to $800,000 range, which required this equity line of credit to be subordinated. She may not know details about the subordination, but certainly it was a requirement of her loan transaction, and she has not presented any evidence that her applications for either of these subsequent loans were anything otherwise than it had to be subordinated. And those loan documents probably set forth that this loan existed when she submitted her loan application, but we'll never know because it was not submitted in that prior action. And finally, she failed to repudiate this loan. It wasn't until well after the foreclosure was commenced that she decided to make this argument that it's not her signature. And we believe those factors conclusively establish that the loan is valid and enforceable through ratification or otherwise. In conclusion, we respectfully request that this court affirm the Court of Appeals opinion and that the note and deed of trust are valid and enforceable against the appellant, Virginia Godfrey, and that Appellee Paper Profits LLC is entitled to an order allowing foreclosure under the deed of trust. If there's no more questions, I thank the court.
Thank you, counsel. Rebuttal.
Just briefly, Your Honors. Couple points. The first one being, I heard the presentation by Mr. Pressel, and he kept saying, you heard that she went in and argued to the district court. She made the argument, but you never heard what argument she made. That's because there was no issue, no argument raised in the domestic action or any insinuation that this debt was valid or that it was valid and enforceable against her. And I think that's the point that the dissent makes at the Court of Appeals, was that there's really no issue that was determined or is determinative in a subsequent non-judicial foreclosure proceeding. There's no allegation that it was valid. There's no judicial determination it was valid. There's not even a judicial determination that it was a marital debt. I mean, honestly, the invalidity or validity of the debt for purposes of that equitable distribution proceeding is completely and was not at issue at all. I think the main concern, given the underlying circumstances, was how fast can I get this house in my name so my absconded, now to be separated ex-husband doesn't keep following me around, like doesn't have the SEC knocking on my door. That's the main concern of why there was such an urgency. Again, you didn't hear what she argued, because what she did not argue is that the debt was valid. She never said that. She never alleged that. That's not binding. There's no position that she's taking in this foreclosure proceeding that's inconsistent with that. Second, I heard that the General Assembly has declared that certain agreements have to be in writing, and that I guess from what the argument I heard was deeds of trust don't need to be in writing or don't need to be signed by husband and wife. When in fact, NC Gen Stat 22.2 says just that. They are void unless they are in writing and signed by the party to be charged therewith. Clearly they're void. The General Assembly, just like they did with separation agreements, has made a determination that these types of contracts regarding conveyance of property have to be in writing and have to be signed by the parties to be charged. In this case, Ms. Godfrey, one of the owners, or else they're void. I'll address briefly the slippery slope argument. That slippery slope slopes both ways. Every judicial or non-judicial foreclosure proceeding in this state has a litany of holder affidavits. If we're going to require that every borrower come and present live testimony, then it follows that every lender and every holder needs to also present live in-person testimony at foreclosure hearings, which is the whole purpose by which a non-judicial foreclosure proceeding is supposed to be an exigent or a faster process. Nothing's foreclosing, for example, Paper Profits from going to a judicial foreclosure route where they can explore all these issues. They didn't do it in this case. They also didn't meet the elements. And in fact, Ms. Godfrey did not ratify this transaction. On those grounds, we'd ask to reverse. Thank you, Your Honor.
All rise.